environment, equitable sharing, not principle of equity. Now the third one is sustainability of natural resources. So for example, when I speak of this, remember soon after the adoption of this convention, 1992, a beautiful case came up before the Supreme Court. People who come up after us also should be in a position to enjoy this. Now, the fourth important principle, which I just forgot to tell you, happened to be in this case for the first time, the Supreme Court pointed out everyone should follow the principle of institutions should follow the principle of intergenerational equity. Intergenerational equity has to be followed for the simple reason. Remember, family or person or a kid or progeny who come after us also should be in a position to get an equal share. That is the reason, remember, that is being adopted. Now, thereafterwards, remember, the Convention on Biological Diversity was adopted. The state of India became a party in 2002. And thereafterwards, remember, they established the Biodiversity Board, which is in Chennai, functioning very well. And thereafterwards, remember, in 1997, the Members International Committee adopted what we call the Kyoto Protocol. In the Kyoto Protocol, remember, which is nothing but a protocol to the Convention on Biological Diversity. For the first time, they said the clean environment and clean energy and carbon tax. See, I shall repeat. Clean. Now, this is the doctrine, this is the convention. For the first time, it went to the extent of pointing out And another 5% will come through what we call as, remember, hydroelectric energy. So that is the commitment which India was made. And recently, you may be knowing in the Abu Dhabi conference, the other powers who are actually uh, not using fossil fuel energy went to the extent of making a statement. All the states should be compelled not to not make use of what we call as fossil fuel energy. And if it is done, if it is adhered, if it is respected, then only there can be law and order and clean environment. But both the government of India as well as the state of China opposed this. Both the government of India as well as the state of China opposed this in the meeting, conference. They said we have made commitment to the tune of $900 billion in the case of India. China, we don't know. And we cannot allocate money beyond this. And we are trying to produce 40%. Remember, extra power, extra 40% of the present use, that is the statistics, through other sources, maybe solar energy, maybe wind energy, through biomass, through hydroelectric. So we cannot allocate money. So it was at that time, our Sadhguru, he came up with a formula. What he was saying is, remember, he was just giving the river basins. And the river basins, both the sides, remember, there is no plantation at all. And the plantation either cut or have disappeared. And it is time that throughout the river basins, you have to keep plantation growing. And if that is done, groundwater resources will increase. And if groundwater resources will increase, naturally, it will help, remember, the resources at least for the people who live in the area of 10 kilometers to 15 kilometers, wherever it may. Maybe it is Ganga, from Gangotri to, remember, Calcutta. Or here, all the rivers from Kaveri, for example, it takes birth in Markara and joins near Kumbakonam to the sea. All these, 1,500 kilometers or more. There, Ganga, you know it. So this is how energy has to be protected. Now the point is, I come back to the title. So most of the public law which were irrelevant are replaced today. And they are replaced by a law which is suited to the time. And this is done to protect the people of the country, wherever it is, maybe India or other countries. It is done in the larger interest of mankind for everyone. See, we have plenty of resources for ourselves. Resources, we don't have resources for man's greed. We have resources only for man's need. That is what I just wanted to speak to you in the short time. There are other cases as well, plenty of cases which I just wanted to speak because of paucity of time and the next speaker I am not able to. If you have questions, you can ask me.
Yes, sir, there are questions. If you allow me to, then should I read first question?
Yeah, read.
Whether the use of environment and hydro energy is beneficial to the climate in the long run, considering the pollution that they would cause upon their waste management.
Yeah. See, in this research is already being done. And with the research, when it is done, remember, naturally it will have its effect. But then, we always, when we think of using our resources which are found, we take into consideration what is lesser harm. Because when we start using it, now at least the society will be able to sustain it for some time. In the meanwhile, if some discoveries take place, they will immediately change to that new resource which is found, which is taking place. For example, lithium. Almost 22% of the scooters which are in India are made of, they are using this. 14% of the vehicles which run on the roads are run through batteries today. And another 8% of the one are through gas. It may be biogas or it may be the gas which is available, CNG, whatever it is. So that means we are encouraging. And the Minister of Transportation actually came on the stage and he has been telling, see some of the videos, you get the full statistics. I cannot give in 1 hour. That much of statistics he has given. So this is ultimately for the welfare. And all the countries, including the state of United States, They initially they have found and used an energy or a source which is of lesser harm. And when they find out new things as per the discovery, they make use of it. For example, I will try to give an illustration under the what we call as the Vienna Convention of the ozone layer, as well as the Montreal Protocol that was adopted to it in the year 1978. Now, most of the developed countries are supposed to give assistance, assistance to the Indian industries to overcome or not to use what we call as the release of fluorocarbons, CFCs, in their refrigerators and air conditions. The point is, in spite of mentioning in the convention, how many of them have given? And if at all they have given outward technology. The present government of India knows if you ask for technology, they will be giving a secondary technology. And they don't want to do it. They want to do on their own. That is why your Skill India has come. And when we develop, we will shift to that. That is what we have done in the last 10 years. So many shifts have taken place, which is reasonable, which is going to save the resources. That is being made use of. Any question?
Thank you so much, sir, for the enlightening session. Now I would request Dr. Shobita Srivastav, sir, the convener of FDP, to say a few words.
Thank you so much, Professor Dr. T.R. Subramanya, sir. Sir is the Dean of Legal Studies at CMR University. Sir established certain research centers and has also launched a UGC Care listed journal. Sir also serves as on various academic boards. And sir, thank you for bringing this valuable insight to our today's guests and faculties. And thank you so much for this insight on the lecture and subject for today. And sir, thank you for being very kind to join us and give your time.
Thank you.
Thank you so much, sir.
Thank you,
And
sir.
I
Thank
see
you.
that our next guest is also here, guest resource person, Professor Prabhash Ranjan, sir. So
Yeah,
we are
can you
eagerly waiting for you for your lecture, sir. I'll just pass on the mic to my anchors for the day, and very shortly we'll begin with your session. Thank you so much.
Moving forward, our next session focuses on Supreme Court and international law. As globalization strengthens, the intersection of national and international law is becoming a more relevant than ever.
To take us through and thought-provoking decisions, we have with us Professor Dr. Prabhas Ranjan, a renowned professor at Jindal Global Law School, holds a PhD from King's College London and an LLM from SOAS and UCL. He has been an Alexander von Humboldt Fellow in Germany. He also served as an International Fellow at the National Institute of Military Justice, Washington, D.C. His extensive research and expertise in international law make him the perfect guide for this session.
Yes. Over to you, sir.
Thank you so much. I hope you can.
Sir, it's over to you now.
I hope you can.
Sir, I think that you're muted. You're not audible.
I now yeah.
Yeah, can you hear me?
Yes, sir. It is now. Yes, sir. You're audible now.
Okay. Thank you very much for this kind invitation. I'm grateful to Dr. Anil Variath, and I'm grateful to all of you for this opportunity. So, as it was said, I'm going to speak on Supreme Court and international law. The endeavor of this session is to trace how Supreme Court has dealt with international law over the years. And I'm going to talk about Supreme Courts dealing with international treaties, Supreme Courts dealing with customary international law, and I'll try to critique some of the decisions. I'll try to problematize and also try to show that how the Supreme Court hasn't been very consistent in its approach when it comes to dealing with international law. I hope you can see my slides as well. Okay, fine. Thank you. How do I move my slide? I think I'll have to. Yeah. So we all know that globalization has augmented the encounter between domestic legal norms and international law. And this has led to a greater interaction between domestic courts and international legal norms. So international law today is not a distant law which doesn't affect us. International law affects the life of many ordinary people in ways that people often do not understand. So therefore, because of this deeper and greater interaction that we have between domestic legal norms and international law, it has become imperative to understand how we deal with international law. Now, the first thing that I'm going to talk about is the institutional structure that we have, in terms of dealing with international law, and what is the theoretical framework in which most of the discussions on international law takes place. Now, if we look at, historically, what is the relationship, or what are the theories that govern the relationship between international law and domestic law? We generally find that there are two primary theories that deal with this. First is the theory of dualism, and according to this theory, international law and national law are two separate legal systems, right? So international law can become a part of the domestic legal system only if it has been specifically transformed into domestic law through an enabling legislation. In other words, just because a state is party to an international treaty, for example, this international treaty on its own will not become part of the domestic legal system of that country, right? So this is the theory of dualism, which looks at international law and national law as two separate legal systems. When an international treaty is incorporated into domestic law through an enabling legislation, this is known as the process of transformation, right? So which means that international law has now been transformed into domestic law, or has been incorporated into domestic law. I'm sorry. Yeah, on the other hand, the second theory is known as the theory of monism, which basically considers international law and national law as part of an inseparable legal framework. So monists oppose the strict division of the law between international and municipal, as argued by dualists. Therefore, according to monist scholars, or according to the monist school of thought, international law is automatically incorporated into the domestic legal system of the country. There is no need for international law to go through a process of transformation by the state. In other words, there is no need for the state to enact an enabling legislation in order to implement international law. International law on its own is part of the domestic legal system. So these are the two basic theories that we have to keep in mind, because whenever we approach any subject of law, the first thing that we should do is to keep the theoretical framework in mind. So monism and dualism that way provide this very important theoretical framework historically. But this theoretical framework has also been subject to a lot of criticism. It has been argued by many scholars that this monist dualist lens to examine the relationship between national law and international law is an archaic one. In today's contemporary world, you will struggle to find a country which is purely monist, or you will struggle to find a country which is purely dualist, right? So states do not adopt a pure monist or a pure dualist approach towards international law, and therefore looking at this relationship between domestic law and international law through the monist dualist lens is an archaic approach, and it should give way to some new theoretical framework. Okay, so one specific criticism that has been leveled by many scholars is that if we look at how courts have dealt with customary international law, and I will talk about this in the course of my presentation with specific reference to India, we'll find that the courts, even in countries that are traditionally dualist, even in those countries, courts have happily incorporated customary international law without any legislative transformation. So the argument is that this is an old theoretical framework, and perhaps it is not so useful in today's context. So then the question is that why are we talking about this, right? Why are we talking about dualist and monist framework if it is an outdated framework or if it's an archaic framework, as some scholars mention? The reason why I think this framework is still relevant, at least for a country like India, is because our courts continue to talk about the monist dualist framework whenever they talk about international law. So since Supreme Court of India has been referring to these theoretical frameworks again and again in most of its decisions wherever it deals with international law, therefore, as a scholar, as an academic, and as a student of international law, therefore it becomes imperative for me to use this theoretical framework to understand the relationship between Indian law and international law. I'll just give you one example of a case. This is a 2020 case, not a very old one, known as Union of India versus Agricus. And I will talk about this case later as well. This case dealt with the relationship between Indian law and international trade law, mainly WTO and GATT. And the Supreme Court of India invoked the theories of monism and dualism in trying to understand the relationship between domestic law and international law, right? So this is as recent as 2020, where the Supreme Court has talked about monism and dualism as the approaches towards this question. So even if internationally scholars might have a problem with these two theoretical approaches, the fact is that since the Supreme Court of India continues to employ these theoretical frameworks, therefore we need to understand, or as an Indian lawyer or a student of I briefly wanted to talk about. Now I will talk about what is the institutional structure or constitutional structure that we have vis-a-vis international law. Now, there are some of these provisions, I'm sure you know about these provisions, but it would still help to revise or sort of reflect on what these provisions are and what do they say on international law. So the first and foremost constitutional law provision is Article 51C, which says that the state shall foster respect for international law and treaty obligations in the dealings of organized peoples with one another and encourage settlement of international disputes by arbitration. So there is a clear recognition in the Indian Constitution that as far as possible, the state shall foster respect for international law and treaty obligations. This is very profound in the sense that when the Indian Constitution was enacted in 1950, when it came into force in 1950, there was a lot of international law that already existed at that point of time, right? Since India was under colonial rule, India did not play an active role in the creation of this international law. A lot of that international law was developed, especially customary international law, was developed without the involvement of several third world states such as India, right? Despite India not playing a role in developing these customary international law norms, Indian constitution makers still wanted India to respect international law, right? So this tells you about the vision that our constitution makers had towards international law. They always wanted India to be a nation that abides with international law. And this is the principle which is reflected in Article 51C. So, for example, they could have also said, if they were to adopt a very parochial vision, they could have also said that since we have not played any role in the development of international law, since we were a British colony for last 200 years, when the Westphalian modern international law developed, since we did not play any role in that, therefore we will abide by international law only that binds us, and we will decide that on a case-to-case basis, etc. That is not vision by saying that the Indian state shall foster respect for international law. So this is the key provision. And whenever you find the Supreme Court dealing with international law, right, 51C is the hook. 51C is the handle through which they get to international law. Okay, so it's like what fishermen throw in the ocean or the river to catch fish. 51C is that equipment which helps to incorporate or import international law into the Indian legal system. Apart from 51C, we also have Article 246(1). Very briefly, I'll mention that, which says that notwithstanding anything in clauses 2 and 3, that is 246 clause 2, 246 clause 3, Parliament has exclusive power to make laws for any of the matters enumerated in List 1 in the 7th schedule, right? And what is List 1? We all know List 1 is the Union List, and entry 14 of the Union List specifically says entering into treaties and agreements with foreign countries and implementing of treaties, agreements, and conventions with foreign countries, right? So in other words, if you read 246(1) and entry 14 of the Union List together, it means that the Parliament has the power to enact a law, right? Or to make a law which pertains to entering into treaties, right? Or which pertains to treaty making, for example, right? Till date, we don't have a law on treaty making, right? Treaty making is exclusively the domain of the executive, right? We don't have a law on treaty making in that sense. It has evolved only through practice over the years. But 246(1), read with entry 14 of the Union List, gives the Parliament the power, right? At least the theoretical power to enter into treaties and agreements with foreign countries, and also to devise how these treaties would be implemented, right? And then, of course, we have Article 73(1)(a), which says that subject to the provisions of this Constitution, the executive power of the Union shall extend to matters with respect to which Parliament has power to make laws, which in other words means that through 73(1)(a), the executive has power over entry 14, that is entering into treaties and agreements. Sorry. I'm a little not that tech savvy, so please pardon that bit. And finally, I want to talk briefly about Article 253 of the Indian Constitution. So 253 says that notwithstanding anything in the foregoing provisions of this chapter, the Parliament has power to make any law for the whole or any part of the territory of India for implementing any treaty, agreement, or convention with any country, right? So if India has to enact a law, and this is where the dualist nature of Indian Republic becomes very clear. If India has to enact a law in order to implement an international treaty obligation on a subject that happens to fall in the state list, say agriculture, for example, right? Or any other subject, the Parliament has the power to make a law on that subject, right? Under Article 253. So Article 253, if you look at this, if you read the statement of object and reasons of many legislations that are enacted or that have been enacted by the Parliament to implement international treaties, you will always or often find reference to Article 253 there, because it is Article 253 which empowers the Parliament to enact legislations implementing an international treaty. So this is the institutional framework or the constitutional framework that we have. And if we look at this constitutional framework together, right, if we look at 73(1)(a), 246(1), Article 51(c), read with Article 253, the net conclusion that we derive is that India is a dualist state, right? International law on its own is not binding on the Indian courts, right? International law on its own is not a part of India's domestic legal system, unless or until that international law has been incorporated, right, through an enabling legislation and made a part of the Indian legal system. So I'll just give you one example. There is this anti-dumping agreement, which is part of the WTO treaty. Now, if you look at the Customs Tariff Act of 1975, it is the Customs Tariff Act of 1975 which implements the anti-dumping agreement at the WTO, right? So this legislation then becomes the enabling legislation in order to implement international law as part of India's domestic legal system. But if there is a treaty that India has signed, right, and if there is no domestic law which implements that treaty, right, then that treaty on its own, as per the dualist tradition or as per the dualist theory, will not be part of the Indian legal system. So the constitution makers or the constitution design is directed towards a dualist school of thought or a dualist theory, which is not very different from several other common law systems such as the UK and Canada, for example. Okay, Now, with having understood the theoretical framework of dualism, monism, having understood the constitutional law framework on international law and domestic law, let me now come to specific dealing of treaties, and then I will deal with customary international law. So when I'm talking of dealing with treaties, of course, I'm talking about how the Supreme Court has dealt with international treaties, right? With international treaty law. And I'm going to divide this discussion into 4 stages, right? I'm going to talk about the first stage, which I call as the early days, where the Supreme Court emphasized on the doctrine of dualism. Then I'll talk of a period, which is the second phase, where the court moved away from the doctrine of transformation or dualism and started to judicially incorporate international treaty law into domestic legal framework. Then third, I'll talk about the situations where the principle of dualism kept on reflecting, right? So it is not that dualism was completely done away with, dualism kept coming back. And fourth, I'll talk about those cases where the Supreme Court has judicially incorporated even those treaties that India has not signed or ratified. And this, I think, is very interesting, or should be very interesting. Okay, so let's straight away start with the early days, the first phase that I'm talking about, this first early phase of doctrine of dualism. So there was this case known as Magan Bhai Ishwar Bhai Patel versus Union of India way back in 1969, which involved the cession of Indian territory. And the court held that under the constitution, obligations arising under agreement or treaties are not by their own force binding upon Indian nationals or others, right? So the court said that the power to legislate in respect of treaties lies with the parliament, and enacting a legislation is necessary when the international treaty restricts the rights of citizens or modifies the laws of the state, right? So the court in this case, Magan Bhai Ishwar Bhai, very categorically laid down the provision of dualism being an important part of the Indian constitutional system. Likewise, there's another case which I want to talk about. This is known as Jolly George Verghese versus Bank of Cochin. This was a case involving the arrest and detention of an individual, and the issue of enforceability of Article 11 of the International Covenant on Civil and Political Rights became an issue. So the question was that whether this Article 11 of the ICCPR is part of the Indian law. The court held in this case, in Jolly George Verghese versus Bank of Cochin, that ICCPR, in the absence of domestic legislation, and please pay attention to these words, in the absence of domestic legislation, is not an enforceable part of the corpus juris of India, which means it is not part of the Indian legal system. You can't enforce the ICCPR before an Indian court because there is no domestic legislation incorporating it, right? So, in other words, the court basically put its stamp on this on this thinking that until the municipal law is changed to accommodate the treaty, what binds the Indian courts is the former and not the latter, which means what binds the Indian courts is the domestic law and not international law. Likewise, moving forward, if you look at as recent as 2004, which is just two decades ago, in a case known as West Bengal versus Kesoram Industries, again, while discussing this issue of interpreting domestic law in light of international treaties, the Supreme Court, SCI here means Supreme Court of India, the Supreme Court again reiterated the legal principle held in cases like Jolly George Verghese, and the Supreme Court said that it is the doctrine of dualism, not monism, that prevails in India, and therefore an international treaty signed by India cannot become part of the Indian legal regime unless the Parliament, using its power under Article 253, has enacted a legislation transforming that treaty into domestic law, right? So this is the phase, or these are the cases which clearly identify, or which clearly fall in one strand, as I have identified, the strand of cases where courts have scrupulously followed the doctrine of dualism. Okay, they have scrupulously followed the doctrine of transformation, in sync with what the constitutional framework provides. That international treaties are not part of domestic legal system unless or until they have been incorporated or transformed into the domestic law by the Parliament through an enabling legislation. Now I come to the second strand of cases, right, which I mentioned earlier. And in this strand of cases, the Supreme Court has moved away from the doctrine of transformation, right? So although there was a 2004 decision in the Kesoram Industries case, which I mentioned, which talked about dualism, the Supreme Court's position on the relationship between international and municipal law in the intervening period from Jolly George Verghese till Kesoram from 1980 till 2004 has actually undergone a change. Okay. Now, the Supreme Court in 1984, in this case known as Gramophone Company versus Birendra Bahadur Pandey, dealt with the issue of international law, whether it becomes part of domestic law. And the Supreme Court said in this case, and I quote, that the Committee of Nations requires the rules of international law may be accommodated in the municipal law, even without, and these words are very important, even without express legislative sanction, provided they do not run into conflict with acts of parliament. Now, this is very interesting and fascinating, because what the court is saying is that international treaties are part of the Indian legal system, even if they have not been incorporated or transformed through a domestic legislation, right? As long as this international treaty is not inconsistent with a domestic law, right? Which means, this takes us to the next logical conclusion, which means that if India has signed an international treaty which contains a provision which is not inconsistent with any Indian domestic law, then even if the parliament has not transformed or incorporated it into domestic law, that treaty would still be part of the Indian legal system. So in other words, I say that the Supreme Court of India unequivocally laid down the doctrine of incorporation, right? That is, the rules of international law are incorporated into domestic law, into national law, without going through the process of transformation, right? With the only caveat that this should not be inconsistent with domestic law. If it is inconsistent with domestic law, or if it appears to be inconsistent with domestic law, the court would do its best to harmonize the domestic and international law. If such a harmonization is not possible, for example, then of course the domestic norm will trump international law, or domestic law will jump international law. Trump might bring other things to our mind. Okay, the same principle has been upheld by the Supreme Court in several cases, including the seminal case of Vishaka versus State of Rajasthan, which gave us the Vishaka guidelines on protecting women from sexual harassment at workplace, right? So in Vishaka versus State of Rajasthan, I'm sure you all know that the court recognized there is no domestic law for protection of women from sexual harassment at workplace. And the court actually provided or developed the legal principles, which then were followed till, I think, 2013, when the parliament actually enacted a law on this subject. And Chief Justice Verma at that point of time, who authored this judgment, borrowed heavily from international law to create what were known as Vishaka guidelines, right? And many of these provisions were actually not transformed into domestic legislation, but he judicially incorporated them to develop what we call as Vishaka guidelines. So this is the phase where these are the cases where Supreme Court has moved away from doctrine of transformation towards doctrine of incorporation. Okay, but does this mean that Supreme Court has, so can we say that in the early days, Supreme Court followed doctrine of transformation or dualism, and then from 1984 onwards, Supreme Court moved towards doctrine of incorporation or monism? It might be tempting to make that conclusion, but I can't make that conclusion because there are cases, as I said, the Kesoram Industries case, which was decided much after Vishaka, much after Gramophone Company. And in this case, the Supreme Court basically laid down the dualist principle, right? So I call this as dualism continues to rebound, right? So we started with dualism. Then there is a phase where we talk about the Supreme Court follows monism. But while it is talking of monism, you also have a rebounding, or you also have a resurfacing of dualism in cases such as Kesoram Industries, right? As recent as I said at the beginning of my talk, in 2020, the Supreme Court in this case known as Union of India versus Agricus, the Supreme Court once again reiterated the principle of dualism, right? The Supreme Court said that unless or until a treaty has been transformed into domestic law, the treaty is not part of the Indian legal system. So we see that today, before I come to this part, we see if we divide these cases into these three strands or three buckets, as I have done, and this is based on a paper that I had published recently, we clearly find a set of cases that align with dualism, a set of cases that align with monism, right? And these two patterns have not been consistently followed. Okay. Now I come to the fourth strand or the fourth pattern that I observed in my research, which I would like to share with all of you, which is that the Supreme Court, interestingly, has incorporated treaties to which India is not a party. Now, this is very fascinating, right? That how, we all know how countries become bound by treaties, right? A treaty is binding on you only when you have voluntarily accepted to be bound by that treaty. Okay. If you have not signed a treaty, that treaty is not applicable on you, right? It's as simple as that. That treaty may still be part of international law, but that treaty is not applicable on you. But in quite a few cases, right, the Supreme Court has actually, and I talk about one such case, which is MV Elizabeth versus Harwan Investment. The Supreme Court in this basically incorporated treaties which are not, or which India has not signed. Okay, this is very fascinating because then it creates an interesting situation where although India has not accepted an international legal obligation, but that international legal obligation becomes part of India's domestic legal system, right? So how does this work, right? There's a question. Can I take questions now, or do we take questions towards the end? I'm fine with
At the end of the session, please.
Okay, fine. Just give me another 15 minutes. I'll complete my presentation, and then we can focus. We can spend the next 15 minutes to take your questions.
Sure, sir. Okay.
Yeah. So I've talked about how the Supreme Court has dealt with international treaties. Now let me talk about how the Supreme Court has dealt with customary international law. This is again a very important conceptual point which often gets mixed up, especially within the Indian legal community, which primarily deals with domestic law. We always look at international law as one animal, right? International law is one animal, but this animal has different parts. Okay. And or it has different sources, as you would know from the statute of the ICJ. Now, international treaties are obviously a very important source of international law, but another very important source of international law is customary international law. Okay, and what is a custom? Obviously, is often a contested question, right? So, as any student of international law would tell you that custom would basically require two things. There should be consistent state practice, and there should be opinio juris, right? That the state should be doing or following that practice from a sense of legal obligation or legal belief, right? So how has the Supreme Court dealt with customary international law? This question came up in a case known as PUCL versus India. And the Supreme Court said that it is almost an accepted proposition of law that rules of customary international law, it specifically said rules of customary international law, right? It didn't say rules of international law. It said rules of customary international law, which are not contrary to the municipal law, shall be deemed to be incorporated in the domestic law. Okay. So you can clearly see that the Supreme Court here is again talking about a doctrine of incorporation. It is incorporating customary international law, even if there is no domestic law which implements those customary international law norms. It is saying that those customary international law norms are very much part of the Indian legal system, unless or until there is something which is inconsistent to it in the domestic legal system. And this has been followed in several cases. This was also followed in another case known as Law Citizens Welfare Forum versus Union of India, right? Now, the problematic part here is that whenever the Supreme Court says that customary international law norms are part of India's domestic legal system or are judicially incorporated, the decisions, I mean, if you read these decisions, PUCL versus India or, Vellore Citizens Forum case, you will find that there is no discussion. There is no discussion on whether that particular principle is indeed part of customary international law or not. I mean, you have to first ask yourself that whether this norm, which which one side or which someone is championing as part of customary international law, is this norm actually a part of customary international law, right? In other words, you have to first ask the question. You have to undertake a rigorous process to find out whether a rule is part of customary international law. And the Supreme Court often does not undertake or often does not perform this function. There have been occasions especially in the two cases which I mentioned, where the Supreme Court has referred to soft law instruments, right, to read customary international law into domestic law. So as a result, this may lead to a situation where those rules that have still not been recognized as part of customary international law are being read into the domestic legal system, which means something is not part of international law and yet it becomes part of the domestic legal system. This, I think, could be a problematic feature. Okay, but this also does not mean, again, there is an inconsistency here. I mean, pardon me, I've tried my level best to find how the Supreme Court has inconsistently dealt with this over the last 70 odd years. Even on the dealing of customary international law, I don't find a consistency. Okay, so while there are some cases where the Supreme Court has said that customary international law is judicially incorporated, which we just discussed, there are also some cases where the Supreme Court has not followed this doctrine of incorporation. And a very important case here is not a very old case, maybe just a few years back, a case known as Muhammad Salimullah versus Union of India, a case which basically involved the deportation of Rohingya refugees to Myanmar. And this case arose when a petition was filed before the Supreme Court seeking to stop the deportation of Rohingya refugees to Myanmar, where we all know they are facing persecution. I mean, this is a matter going on at the ICJ, at international forums. Now, the petitioner in this case invoked the principle of non-refoulement in international law. Now, what is this principle of non-refoulement in international law? It's enshrined in Article 33(1) of the Refugee Convention. So RC here stands for Refugee Convention. You will find this principle also in Convention Against Torture and other international treaties or international conventions. Now, the principle of non-refoulement basically means that if someone is facing persecution in a country, or if there is a fear that the person will face persecution in that country, then that refugee should not be deported. So if there are refugees in India who we know that will face persecution in, say, some other country, then those refugees should not be deported to that country. This is the principle of non-refoulement. And this is reflected in Article 33(1) of the Refugee Convention, as I mentioned. So how did the Supreme Court deal with it, and why customary international law is important? The Supreme Court in this case basically did not deal with customary international law at all. Okay, so what was Supreme Court's reasoning? Supreme Court basically said that Refugee Convention is not binding on India because India has not signed it, which is true. India is not a signatory to the Refugee Convention. And since India is not a signatory to Refugee Convention, therefore Article 33(1) or the principle of non-refoulement does not apply. Fine. But this does not answer another very important part, which is, what about the argument that non-refoulement is actually part of customary international law? Right? This has been recognized by many scholars. There are few scholars who say that non-refoulement is not part of customary international law, but there's considerable consensus on the view that non-refoulement is part of customary international law. Now, if non-refoulement is part of customary international law, right, then even if India has not signed the Refugee Convention, this part of Refugee Convention is still binding on India, right? Because customary international law is universal. Unless or until a state has been a persistent objector to the formation of a particular custom, that customary international law will continue to bind or will continue to apply on India or on any country for that matter. Now, if India has not signed the Refugee Convention, then the whole of Refugee Convention is not applicable in India, which is fine. But that part of Refugee Convention which has attained the status of customary international law, namely the principle of non-refoulement, is binding on India, right? And the court did not deal with this question, that if it is part of customary international law, then do we still judicially incorporate it, or do we say that it can't be incorporated, right? So the court's reasoning is flawed, is incomplete. Okay, it did not fully grapple with the phenomenon that this is part of customary international law. If it had grappled with that phenomenon that this is part of customary international law, then following the line of reasoning in the previous cases, the Supreme Court should have said that this principle is part of the Indian legal system, even if there is no Indian law on this, and therefore these refugees can't be deported to Myanmar. But that is not what the Supreme Court said. The Supreme Court, the other logical argument could have been, Supreme Court could have contested that no, non-refoulement is not part of customary international law, and therefore it can't be incorporated. You may still have disagreements with that reasoning, but at least that reasoning is academically rooted, right? That reasoning is saying that this is not part of CIL and therefore it can't be judicially incorporated. But that is not what the Supreme Court said. The Supreme Court did not deal with this question at all. And I think that is a major flaw in its dealing with international law, right? So this brings me to the conclusion, and then we can, I'll be happy to take your questions. And I have, as you can see, I have 4 conclusions, okay? So my first conclusion is that while the normative framework given in the Indian Constitution on the relationship between international law and domestic law is that of dualism or doctrine of transformation, the Supreme Court of India, broadly speaking, has departed from the principle of dualism. So the court has moved away from what the constitutional framework provides for. That's the first point. The second point, notwithstanding this broad movement away from dualism, which means towards monism or monist incorporation, the Supreme Court of India's jurisprudence on this question is riddled with inconsistencies, as I have tried to demonstrate in my presentation and as I've argued in my research. So on the one hand, if you look at Supreme Court's approach in cases such as Union of India versus Agricus, the court continues to reassert the principle of dualism, but the reassert the same Supreme Court of India, in the famous Puttaswamy, which gave us the right to privacy, approves the doctrine of incorporation. Okay, so while there is a broad movement towards monist incorporation, even this monist incorporation is riddled with inconsistencies. Okay, that's the second point. The third point, that the Supreme Court, though conflictingly, has also incorporated international treaties that India has not signed, and this I find to be deeply problematic. International treaties India has not signed creates a bizarre situation because India is not bound by a treaty internationally, but such a treaty would be considered part of the domestic legal system, which I think most of you would agree with me is a bizarre situation. And that's the third point. And finally, the fourth point, the fourth conclusion, that in the process of incorporating customary norms under international law, there is a flaw in the court's methodology. You know, this is something as lawyers or as law professors we need to understand. Supreme Court is supreme not because it is supreme because the legitimacy that the court draws, okay, does not come only from the decisions that it renders. The legitimacy of the court also comes, or primarily in my opinion comes, from the reasoning that it employs in giving its decisions, and how strong, how robust those reasoning or those reasons are. And if those reasons are problematic, from a methodology point of view, then as academics, it is our dharma to point that out, right? And that is precisely what I'm trying to do. So I find a flaw in the court's methodology, which has been that whether something has indeed become part of customary international law, this question has not been dealt by the Supreme Court in most of the cases. Supreme Court needs to at least ask this question, at least look at the international law, the literature, and then come to the conclusion that something is part of customary international law. How can you incorporate something just because you believe it's part of customary international law without testing whether it is actually part of customary international law, right? So therefore, this is one flaw that I find. While this may be true for domestic courts in several other jurisdictions, so it's not that Supreme Court of India is the only one that is doing it. There are examples of domestic courts. I mean, I didn't have the time to go into it, but there are examples of domestic courts, especially in Latin America, etc., that actually undertake a rigorous analysis in deciding whether something is part of customary international law before it is judicially incorporated. And I think the Supreme Court of India needs to follow those examples. So the long and short of the story is that the Supreme Court has dealt with international law in a manner which has not been consistent. It has moved away from the constitutional framework that was provided, and that per se is not problematic, as long as that departure or that movement away from that constitutional framework is consistent and has robust reasoning. And I think that is what is missing in the jurisprudence of the Supreme Court on dealing with international law. So I'll stop here and I'll be happy to take the questions. Thank you.
Yes, sir. There are a few questions. You want me to read the questions for you, or you'll read the questions from the chat box?
It would be good if you can read it for me, if you don't mind.
Sure, sir. Sure. The first question is, does the Supreme Court balances national sovereignty with international legal commitments?
Yes, it does. And any court will have to do that, right? But let us also keep in mind that when India or any country for that matter signs an international treaty or accepts international law, that is also an act of sovereignty, right? The country is voluntarily accepting restrictions on its international legal on what it can do or what it can't do, right? So entering into international treaties in itself is an act of sovereignty. Now the court, of course, has to balance. I completely agree and see that point. But in balancing that, the court has to at least have a consistent legal reasoning.
Yes, sir. There is another question. You mentioned soft law instruments in the slide. Can you give any example?
Yeah, so soft law instruments, for example, UN General Assembly resolutions are soft law instruments. Declarations which are adopted at UN conferences or at any conference for that matter is a soft law instrument. In the specific case that I was referring to, the question was whether sustainable development has become part of customary international law. Now, there are quite a few soft law instruments on sustainable development, but it is contested whether sustainable development in itself is part of customary international law, right? So you can't come to such a conclusion or such a decision only relying on soft law instruments, right? This does not mean that you can't rely on soft law instruments. This also does not mean that soft law instruments are of no use. Soft law instruments do play a very important role in shaping the law, in influencing the law, in norm evolution, in norm creation, right? But soft law instruments are not, as the word suggests, it's soft law, right? It's not law, it's not hard law, it's not binding law, and therefore you can't. Soft law instruments can't be the basis for you to make a final determinative conclusion.
Sir, the third question is, what is the influence on judiciary in situations where a state is just a signatory and where it has ratified a treaty? Enforcing a non-ratified treaty should be an exception or practice. Is it also a question of judicial overreach?
It is a question of judicial overreach, undoubtedly, that you incorporate a treaty which India has not signed or ratified. Now, it's important in those situations that the executive has to make this strong argument before the court that this is a treaty which is not binding on us, and even if you were to follow the principle of judicial incorporation, monist incorporation, as I talked about, even then you can incorporate something only when it is part of the legal system, right? When it is not binding on me, then how do you incorporate that as part of the domestic legal system? If it's a customary international law norm, that's a different that's a different case. But if it's a treaty that India has not ratified, and if that norm which is being questioned is not part of customary international law, then interpreting it, incorporating it as part of the Indian legal system, I find that to be problematic, and a case of judicial overreach. Yes.
So the fourth question is, how will Supreme Court carry these interpretations through engaging experts or getting the standpoint of government? Do you think there is a need for specialized institution for international law in India?
Yeah, that's a tough question to answer. Let me first say that international law, unfortunately, is not taken very seriously in India. I mean, that's the angst of an academic who does a bit of international law. That international law is not taken very seriously. There are some institutions. You do have the Indian Society of International Law, for example, ISIL. So specialized institutions may help, but what is more important is a vision that we need to develop our international law expertise. I'll give you one example. Take the example of China. How many Chinese international lawyers were active on the global scene 2 or 3 decades back? Very, very few, right? I remember attending conferences on trade law, 17, 18 years back. You will barely find anyone from China, right? It would be like one person from India, one person from China, right? It was something like this in 2007, 2008. Today, if you attend any such conference, right, you'll find only 1 or 2 people from India, or maybe 3 people, right? But you will find 25 people from China. This shows the kind of investment that they have made. Now, why have they made this investment? Because they know that we need people with skills in international law, because we need to conduct our business internationally, right? And the business here does not mean only commercial business. We have to deal with the world at large, and we need people who are specialists in international law. So India has produced great diplomats, right? And we have great diplomats. I mean, that supply continues because we have the Indian Foreign Service, for example, to recruit those diplomats. But do we have so many international lawyers? We do have a few international lawyers who are outstanding. But for a country that is 1.4 billion, you certainly need much more international lawyers, right? And that has to start by fostering international law teaching within our law schools, which unfortunately is not happening. Because let's not forget, the people who go on to practice in the court and then become judges have also gone through the same system. So if they have gone through a system where international law was not taught well, international law was not taken seriously, that dismissive attitude towards international law would continue to prevail. And then that individual, when sits on the bench, will have the same attitude, and perhaps that is the reason why we have so many inconsistencies. I don't know if that's an answer, but yeah, that's what I can say on your question.
Thank you so much, sir, for answering all the questions. If you allow me to read out one more question, there's the last question.
Sure, please.
Thank you, sir. So, sir, the last question gives reference of your article given in the Hindu. You discussed the dismissal of a PIL which sought to stop the export of defense equipment to Israel amid the Israel-Hamas conflict. Should the court, in your view, have incorporated IHL considerations into its review, thereby taking a more monist approach? What are your views on this?
Yes, the Supreme Court should have done that, and that decision for me was, well, it was not a decision in that sense. It was a dismissal of the PIL, but since it was heard by none other than Chief Justice of India, D.Y. Chandrachud at that point of time, I expected more robust reasoning, even if you were to dismiss the PIL. My in my analysis as an academic, I don't quarrel with the decision as such. You may arrive at any decision, that's the court's wisdom. I always quarrel or pick up fights with the reasoning, because it's the reasoning which will take you to the decision, right? So in that case, I think the Supreme Court should have incorporated principles of IHL into the Indian legal system by following the lines of Vishakha and Puttaswamy, in all those cases, and said that if India is exporting arms to a country, and that country is using those arms, if there is evidence to suggest prima facie that this country is using those arms or those ammunitions or whatever in committing war crimes, then there is an obligation on India as well, right? And India should comply with that obligation, which is not to export those arms to that country. But the Supreme Court's dismissal of the PIL was largely based on foreign policy, and it was based on the executive has the prerogative to decide and domestic considerations. It wasn't really there was international law which was missing there, right? And that, I think, so it is possible that the court could have said, for example, that yes, we can take the IHL norms as part of the Indian legal system, but there is no conclusive evidence to suggest that India's arms exports to Israel are being used by Israel to commit war crimes. That's an allegation, allegedly war crimes, right? So court could have said that since there is no evidence, therefore we can't direct the executive to stop those exports. That decision, I may agree, disagree, but that's a separate point. At least the decision has a robust reasoning, right? But the decision that was arrived at didn't have that robust reasoning, and that's why the problem, in my opinion.
Thank you so much, sir, for this insightful session. Your discussion on the Supreme Court role in engaging with international law has provided us with a deeper understanding of this evolving area of legal studies. Now I would request Dr. Shobhita Srivastav, sir, convener of FDP, to say a few words.
Well, thank you again, sir, for joining us in this FDP. I approached you with certain reservations whether you'll have time to spare for this for this FDP, that too online FDP. But I'm really glad to have you, sir. And it was really an engaging lecture today, because I am also a learner of international trade law and public international law. And the points which you put forth with respect to the practical application of the theory, this is something that as a teacher, I'm enriched with a better knowledge and the practical application of the same to be taught in class. I thank you again, Professor Prabhas Ranjan,
Thank you so much.
to come in this FDP and enlighten us on the topic. I thank all the joinees who are there in the meeting and who are listening us on the YouTube broadcast. We shall resume again tomorrow with our another set of resource persons. The link will be shared online. You'll also get the feedback form through the WhatsApp message. Thank you so much, sir. Thank you for
Thank you. Thank you. All the very best to you and to everyone. Bye-bye.
Bye, sir. With this, we'll end the meeting. Thank you, everyone, and we shall share the feedback form on the WhatsApp in some time. Thank you again.